Every day, millions of people in Britain put their trust and their lives in the hands of the NHS. It's an institution created to take care of us from the womb to the tomb. But doctors and nurses can sometimes fall short in their duty of care to patients. It's estimated that 1 in 10 people admitted to hospital each year will suffer some kind of clinical negligence. This can range from minor errors to incidents that can have life-changing consequences. Up until now, those who suffered at the hands of the health service will be able to seek compensation from the same public purse that paid for their treatment in the first place. But this is all about to change. New reforms to the legal system will deny compensation to all but the wealthiest and are leading to growing claims of a two-tier system. Those who can afford to put things right when their healthcare goes wrong, and those who can't will be denied the right to fight for justice. Acts of negligence can happen at any point in the medical ladder, from the GP's office to the operating theatre. But it's at the top of the clinical tree where the worst cases occur, sometimes leading to injury or even death. I went to meet Anastasia, who had suffered for 15 years because of one reckless surgical procedure. Hi. Nice to meet you. Hello.
When I went to see the consultant, he said to me, he examined me, and he said, Mrs. Inslee, you will need to have a hysterectomy. He said, but basically at your age, everything is redundant in that area. So I took him at his word, because what else can you do? You're totally, in their hands. And I went in the 11th of August 97. He carried out the hysterectomy on me. And I came out of hospital 4 days after, but I wasn't even able to go back to work. I could hardly walk, I couldn't sit. I had to lie on the settee all the time. That's how I was from having the hysterectomy. When I got a second opinion, the consultant examined me and he said, Mrs. Inslee, did you need to have a hysterectomy? He took all my medical history, and I said, well, yes, I assumed I did. If I didn't, why was the hysterectomy carried out on me? They did all sorts of tests, and they had me in under general anaesthetic. And the consultant came back, the colorectal consultant came back, and he said, Mrs. Inslee, he said, you're going to have a colostomy.
And this was all the result of...
And this was all the results, because he carried out the hysterectomy vaginally. He damaged my vagina, he damaged my perineum, he damaged my bowel, and he damaged my bladder.
Anastasia wasn't the only victim. She told me how 300 other women also suffered at the hands of just 2 consultants, with tragic consequences.
I've had 10 operations since then.
All resulting from that?
All resulting from that one unnecessary procedure. We used to enjoy our caravanning and what have you. We belonged to the caravan club. For a long time we weren't able to do that. If I go abroad, wherever I go, I have to have colostomy bags, urostomy bags, night bags, all the other bits and pieces to do with my situation. I have to use a mobility scooter, because if I don't, I can't stay on my feet for any length of time. It's left me disabled for a totally unnecessary procedure.
Anastasia took her case to the General Medical Council. Her doctor, having advanced Parkinson's disease, was deemed too sick to face charges, but was removed from the medical register at his own request. Anastasia received £50,000 in an out-of-court settlement. Yet she may be one of the last able to seek legal redress and compensation for suffering caused at the hands of the medical profession. As part of the Coalition's austerity cuts, the Ministry of Justice is slashing 28% of its budget, and it's our legal system that's paying the price. In order to save £10 million, the government has passed new legislation to remove legal aid from cases of clinical negligence. Legal aid money is provided by the state only for people from the poorest backgrounds to help fund court cases that they otherwise wouldn't be able to afford. Peter Walsh, the chief executive of the charity Action Against Medical Accidents, works with the victims of clinical negligence and their families every day, and knows better than anyone how the new law will affect them.
The legal reforms as they affect clinical negligence are a big mistake. It will result in some of the most vulnerable people in society who've been caused grievous harm, or even where there's been death in a family, being denied access to justice.
Jeremy Corbyn is the MP for North Islington, the 8th poorest district in the country. His constituents are some of the most likely to be affected by the reforms.
I disagreed with legal aid cuts under the previous Labour government just as much as I disagree with them that are being made at the present time. I represent a constituency which 45% of the children are growing up in poverty. Unemployment is above the regional and somewhere near above the, or rather above the national average. And I'm a full, strong supporter of the principle of legal aid. And I think we are doing all of ourselves a disservice when we remove it. Put it this way, if I suffer because of somebody else's negligence, or I suffer because of an injustice in society, I should have the same right to go to court as anybody else, irrespective of how wealthy or poor I am. We don't.
There is a school of thought, you know, that believes that if a thing is scarce, it ought to be dear. Although it doesn't cost any more to produce it than if it were plentiful.
Legal aid was born in 1949, a year after the foundation of the NHS. Both were established on the principle of rights for all, the right to healthcare, the right to justice, regardless of wealth. As a cornerstone of post-war democracy, the demise of legal aid has sparked heated debate on both sides of Parliament, leading to the largest rebellion since the coalition came to power. The bill was batted back and forth between the Houses in a fierce confrontation between Lords and Commons. In all, the Lords tabled 14 amendments to the bill, most of which were overturned. The Commons, however, did agree to keep legal aid for babies who suffer brain damage at birth, but stipulated that only those under 8 weeks old will qualify. The Lords tried to guarantee legal aid for all children in clinical negligence cases, but the amendment was defeated. But the government did relent to keep legal aid for victims of lung disease caused by asbestos. Despite a couple of compromises, the government bulldozed most Lords' amendments with its parliamentary majority. The bill was passed and has now become law. Game over. Carl Turner, MP for East Hull, fought for victims of clinical negligence in Parliament when he tabled an amendment to include all cases within the scope of legal aid.
I just want to say that I'm absolutely opposed to what the government have done in relation to this new piece of legislation. I think it will send us back a long way in terms of accessing justice. The reality is the most vulnerable people suffer as a result of being squeezed out of accessing the court system. People who've got money will always be able to afford to litigate, but people who I represent in East Hull, people like members of my own family who have not got massive amounts of cash in a bank account will be the ones who are closed off from accessing the courts, and that shouldn't be fair. I see access to justice as important as accessing a GP, or if you have an accident going to an hospital and getting stitched up or mended. I think it's as important as that. This government don't, and that's the worry I've got.
This is a cause close to Carl's heart, and like other MPs, he has seen the tragic effects of clinical negligence firsthand with the death of his brother.
My brother basically had an history of alcoholism. He was prescribed something called Antibuse, which is something which stops you drinking alcohol. He was having severe stomach pains and he was going to his GP. I think he went 4 times in 5 days or something. The GP, to be fair, automatically assumed that he'd been drinking. He didn't say it, but he thought he'd been drinking on this drug Antibuse, the effect of which would cause you to have an upset stomach, a severely upset stomach. As a result of that, he immediately assumed he'd been doing that and prescribed Gaviscon. Just discounted the fact that it might be legitimate that he'd not been drinking. As a result of that, Craig collapsed. It was actually peritonitis and septicemia that he was suffering with as a result of a burst appendix. He should have been referring him to the hospital. He should have been ringing an ambulance for him. He just ignored the fact that it might be possible that he's telling the truth. It was negligence. But to take that case to a solicitor, you know, you've got to have a solicitor who's prepared to take on a massive organisation who's got lots and lots of experienced lawyers and, let's be honest, lots of money to fight litigation on a case which is very unlikely to win. So his children would have been left without a father, which was tragic enough, and without the possibility of a few quid to compensate them for the loss of the father. I think they got something like 60 grand each in compensation. But, you know, that was... You know, it was not a fortune, but it was enough for them to sort of start life, going to university and so on. That's what compensation's about.
The government argues that cutting legal aid will not deny victims access to justice. They point to the availability of no-win, no-fee, also known as conditional fee agreements, which currently account for the majority of clinical negligence cases.
They're real lawyers, and they will get you 100% of the compensation you deserve.
For the injured party, this may seem ideal. A lawyer will take on your case with no upfront payment, and if successful, you get to keep all of the compensation, and your lawyer's fees are paid by the losing party. The government has other ideas. Under the new system, the injured party will have to pay their own lawyer's fees out of their compensation. This would mean that the victim could lose up to a quarter of the money that court has ordered they both need and deserve. And on top of this, they will be held responsible for the other side's legal costs if they were to lose. In a two-pronged attack by the government, not only are victims of clinical negligence being denied legal aid, they are being prevented from pursuing other ways of claiming compensation. Yet this double whammy of reforms was never meant to happen. In a review of civil law, Lord Justice Jackson recommended these changes to no-win, no-fee. He intended to reduce payouts to lawyers and stop unnecessary claims reaching court. But Lord Jackson made it clear the changes were to be made while retaining legal aid. The high risks of the new system of no-win, no-fee means that those who used to be eligible for legal aid will shrink away from bringing a claim for fear of the potential costs. So, by placing obstacles in the way of victims, are the government attempting to sweep clinical negligence under the carpet?
You'll find that there's less claims being brought because, firstly, legal aid was an important facility there for vulnerable members of society that effectively couldn't afford to bring a clinical negligence claim. It's not just the lawyer's fees. In order to bring a clinical negligence claim, you need independent expert evidence to establish breach of duty and causation, and those experts charge. Now, those reports cost each time, so a basic clinical negligence claim, in order to bring a case forward, just for those expert reports, can cost $5,000 plus. So for people that were eligible for legal aid, and it looks like they had a claim that should go forward, the legal aid would cover those costs. Now, who's going to cover those costs? In terms of conditional fee agreements, CFAs, as you know, previously under the old system, if the claim was successful, as well as getting the costs back from the defendant, you could apply a success fee. And under the new regime, what will happen is that success fee is allegedly taking out the client's damages, so effectively that reduces their compensation that they needed for their injury. So I think you'll find a lot less cases being brought under that scheme.
In terms of claimants' legal redress, you think that really these reforms are putting up a barrier to justice?
Oh, certainly, totally imbalanced, and it will affect the vulnerable in society that can't afford to pay for meritorious claims effectively. But there'll be the insurers or the NHSLA will still have access to justice to defend the claims, but there'll be this complete imbalance of power. So you'll find that people who've been negligently injured through no fault of their own will have no redress at all. There'll be lots more litigants in person. A lot of the courts have had their staff reduced. A lot of things being centralised, so they're already being jammed. They're under a lot of pressure. You will find that there are firms that will effectively go out of business, and there will be less solicitors that will decide not to pursue clinical negligence cases or personal injury cases because effectively they're unable to, they're not sustainable effectively.
All right.
In a report by young legal aid lawyers titled Nowhere Else to Turn, it suggested that many people will rely on their local legal centres, MPs, and will even resort to representing themselves in pursuit of legal redress. 6,000 lawyers, judges and public servants are taking part today in the London Legal Support Trust's annual legal walk to raise funds for law centres up and down the country. Their aim is to protect the 600,000 people who will be denied access to justice by government reforms.
I'm walking for the Personal Support Unit to raise funds for the charity, and we assist litigants in person in the Royal Courts of Justice and the Family Division.
Brilliant. And what do you hope will happen from raising these funds?
Well, I hope it will help basically to keep the charity running, because we offer a really important service. Obviously more and more litigants in person these days, what with the legal aid cuts.
We're walking because there's a number of London legal aid charities that are supported by this walk. And it's in favour of the London Legal Charities Trust or something, and there are a number of, they will fund the cases where legal aid doesn't apply. So there's already areas where legal aid doesn't apply, and it will only get worse with the legal aid cuts next year.
Much criticism has been laid at the door of so-called fat cat lawyers who use no-win, no-fee agreements to claim excessive success fees. But many do not acknowledge the risks involved for them, or consider the implications if they were to lose.
I think it's pretty unfair of some of the publicity I think that's been out there, profiteering law firms, etc., because it's not the case. It's not how law firms, generally speaking, work. We're not profiteering by them. We are taking the risk for claimants by pursuing their case if we think there's sufficient merit, and if it isn't successful, not getting paid any of our costs that have been incurred in result of that. And I think perhaps that the government do know that because people have that right and law firms have to help them pursue those claims, that perhaps they are somewhat relying on us stepping in and helping people have access to justice that they're now taking away from them.
The government are expecting law firms and charities to step in to bridge the gap after the loss of legal aid. But that's not a certainty, and it hasn't stopped victims of clinical negligence fearing that their suffering will be ignored.
I feel very angry, and I feel that they're letting down patients who have been damaged by the medical profession. They don't have to live with consequences of a medical accident. It's not something that can be put right. Once it's done, it's done. There's no going back. It can't be put right. So therefore you have to live the rest of your life with the consequences of that.
I took Anastasia's concerns to the Ministry of Justice to get some answers. Unfortunately, no one was available to speak to me, but they did give me this statement.
At more than £2.1 billion per year, we have one of the most expensive legal aid systems in the world, which in the current financial climate we just cannot continue to afford. Legal aid is an essential part of the justice system, but it is also in urgent need of reform if we are to deliver the modern, efficient justice system we all expect. Our measures target legal aid at the people who need legal support the most, and on the most serious cases. This means taxpayers will know their money is really helping people and is not fueling unnecessary legal action.
The Ministry of Justice has pointed to the fact that clinical negligence claims have risen from 6,500 in 2010 to 8,500 in 2011. They blame this boom on a so-called compensation culture encouraged by frivolous, no-win, no-fee claims. Dr. Graham Cookson from King's College London wrote about the compensation culture myth in his report on the financial implications of the reforms.
Well, the idea of compensation culture obviously is largely levelled at personal injury and less so at clinical negligence. But even within that, there's been some worries that over the last few years, the number of claims against the NHS has risen year on year. And every year, the NHS pays more and more out. But actually, if you look at it, there's maybe 8,500 people every year against perhaps 1 in 10 people who suffer clinical negligence. So it's unlikely that there's a compensation culture.
How would you sum up the government's proposals in terms of their cost effectiveness?
Well, in terms of the value for money, I think it's relatively poor. The government hopes to save £350 million by changing the legal aid aspects that I looked at. I think they maybe save 40% of that, and there were lots of costs I couldn't estimate, so that's probably a conservative figure. So the government's actually going to save a very small percentage of the amount of money it predicts it's going to save. At the same time, it's denying legal aid to maybe 600,000 people every year. So actually the government saves very little money and hurts a lot of people. That doesn't seem a particularly good thing to me.
For every £1 the Ministry of Justice saves, the government will lose £3 in extra costs to the NHS. That's a doubling of its loss overnight, whilst denying the poorest the route to compensation. The NHS Litigation Authority, who deals with negligence cases, expects claims to fall.
We would expect that legislation to have an impact on claims, and which would reduce them averagely. There may well be other factors at the same time which are continuing to push them up. So the net effect may still be an increase, but we would expect that increase to be lower than otherwise it would have been if the legislation hadn't been passed.
Though the ones who lose out will not be the rich. In fact, there may be a winner in all of this: insurance companies. Justice Minister Jonathan Ginogly, who is in charge of the legal aid cuts, has come out in support of insurance policies as an alternative to legal aid. Yet Ginogly stands to personally profit from the reforms. He has investments worth at least £250,000 in companies with insurance arms, and his family run a firm of insurance underwriters. And that's not all. Financial firms with links to the insurance industry have given nearly £5 million to the Tories since Cameron became leader in 2005. I wanted to find out how much influence the insurance companies had on the government reforms. Unfortunately, the Ministry of Justice will not detail which insurance companies Ginogly had meetings with, but we have strong reason to believe they were heavily consulted in the decision-making process. Ginogly was unavailable for comment. Shadow Justice Minister Andrew Slaughter has been vocal in his criticism of the government's conflict of interest. I asked him why he made a complaint about Ginogly to Cabinet Secretary Gus O'Donnell.
Because we were concerned, and we remain concerned, about the fact that interests which should have been declared were not declared, and indeed we were proved right about that, and the Minister made further declarations. We were also concerned that, that there was not only with insurance companies but also through family links with claims management companies on the other side, and we felt all these matters should be declared, and that and I've never made any allegations personally about Mr. Ginogly and the way that he has behaved, but in politics you have to be seen to be above reproach.
What do you think of Ginogly's kind of application of before the event insurance?
Insurance companies are benefiting massively, obviously, because if people can't sue for industrial disease or personal injury or what have you, they will not have to pay out. If they do have to pay out, their liability is now restricted. If in addition to that, they are then able to replace, or purport to replace, those systems with a system which actually delivers them massive profits by selling before the event insurance, then that actually, is almost rewarding them a second time for not doing the job that they should do, and the insurance industry its best should do, which is to provide some form of safety net.
15 years ago, the safety net was legal aid. Then, 80% of the population were eligible. This has been slashed over the years by both Conservative and Labour governments. Currently, aid is only available for the poorest 20%, and after these reforms, only asbestos victims and brain-damaged babies under 8 weeks old will be eligible at all. But for the poorest, is insurance really an option?
The reforms, as they've been set out in this legislation, are so irrational that one can't help but suspect that there's another agenda here, that the state want to see not just a switching of claims from one system of legal aid to no win, no fee, but they're actually wanting to shut the door to access to justice for some people, to reduce the number of claims that can be made against the NHS. That's very sad because it's sacrificing a long-held principle in this country that everyone deserves access to justice. The other thing to bear in mind is that some of the most vulnerable people don't have insurance at all, and certainly are unlikely to tick the box saying they'll pay another £10, £15 a month in order to have before the event insurance.
In the end, the removal of clinical negligence from the scope of legal aid will have the opposite effect to what the government claims. The reforms will actually end up costing the public purse more than legal aid ever did. But ultimately, the true cost will be people's right to justice. While the wealthiest will still be able to bring a claim forward, the new reforms are effectively closing the door on access to justice for the poorest, creating a two-tier legal system. With the removal of legal aid and the risks associated with the new system of no win, no fee, where are the victims of clinical negligence to turn? Is there anything that will make Ken Clarke change his mind?
What we're trying to set out at the moment is principles, and what we feel this government is doing is balancing or unbalancing the system, so it's in favour of those who already have power and those against whom ordinary citizens are seeking redress. And that may be big private companies, as in the case of, say, industrial disease, it may be insurance companies, it may be the state in terms of clinical negligence. And it's already, a lot of people will say, not a very level playing field, because the individual against the organisation is often at a disadvantage. I can't say exactly how we do it because we'll have to look at the situation on the ground as we find it, but certainly the principle we want to do is to put things back as we hoped they were when the justice system was working as it has been since the Second World War at its best here.
I've said it to Ken personally. I've chased him around the lobby. I've spoken to him in his own room in the House of Commons. He's fed up of hearing from me. He knows my view. I've got a lot of time for Ken Clarke. He's a decent man. He's doing what he has to do or what he thinks he has to do. He's got it wrong on this issue.
I'd like Ken Clarke to come along and meet some of the families we deal with. I'd like to introduce Ken Clarke to families who in the new system, perhaps who have a brain-damaged child who falls outside their very tight criteria for legal aid, who cannot access justice, and explain to that family why he thinks it's justifiable to deny them access to justice.
What I would say to Ken Clarke is, think very seriously about this. I am the consequence of clinical negligence, and it was negligence. I have got a colostomy and a urostomy, and I would say to Ken Clarke, would he like to have to live with that? Would he like any of his family to have to live like that and not be able to get justice?